My lord, now this petition has been filed by me, my lord,
Yes.
against an interim order passed.
Before that, sorry for the
Annexure
interruption.
A.
This was argued on the previous occasion. My lord was pleased to grant me time to argue on my IA. That's IA number 2. I'll make my submissions on that IA number 2. Thereafter, you can reply to that.
My lord, IA
Because
number.
it will be we are taking the case out of the track. Therefore, my lord was pleased to peruse the prayers made in IA number 2 by the respondent.
Your lordship may kindly see, I am for the petitioner. My writ petition is limited to annexure A visitation right. He wants to file an application for going abroad and all. Last time only we made a submission, my lord. This is not a family court. You go there, make the application there. I will be heard, you will be heard. Whatever orders will be challenged. That cannot be filed here, my lord. We can't convert this court into a family court. IA number 2. It is not filed. It is only against an interim order passed in my favor, my lord, which we have called in question in this writ petition, annexure A. That is the impugned order. Your lordship is deciding on annexure A, not on the merits of the case, or original proceedings are still pending. There is no stay order. He can file that. He can prosecute that. We can contest it in family court, my lord. There is no stay of proceedings also. Kindly see, my lord, we have the petitioner before your lordship, my lord, has filed a petition for divorce, my lord, and for custody, my lord.
Why should I be
Impugned
deprived of
order, my lord,
my
is at
liberty to
page
make
number.
submissions to your lordship?
Huh?
I should not be deprived of my lord to make my submissions before your lordship. Last time, all these submissions were made. My lord was pleased to hear both of us on those counts.
Now the question is the petitioner who's come before this court.
I fully agree with all the.
Let me also understand. I think you have read your file. I have not.
I'll
also
make submissions. I'll make.
So now,
Firstly, the petitioner filed a divorce petition in Bombay.
who's the petitioner?
Petitioner is the husband against the wife. Then, in terms of the orders passed by the Honorable Supreme Court, the petition was transferred from Mumbai to Bangalore. It is pending before the family court, which are not, facts are not in dispute at all. Now, the only question that arises for your lordship's kind consideration is, in terms of the objection filed by the petitioner to my application, seeking your lordship's kind permission to alter the visitation rights and permit me to go to England, take my son also to England. That's the simple question that's now involved in my IA number 2.
In your IA.
In my IA. It's for my lord to consider on the basis of the submissions to be made by the wife, whether he can take the child by modifying the visitation rights. That's the simple question.
But that is not the writ petition. That is not in the writ petition.
No, I do agree, Madam. I do agree. I do not say that.
So you're also admitting the fact.
Yes.
You're also admitting the fact
Please, Madam.
that
Please,
your IA is nowhere concerned to the writ petition.
No.
not nowhere, Madam. The writ petition after being filed, there is no interim order of the further proceedings pending before the family court. Then each time, just before the commencement of the vacation, for the last 3 years, custody orders were given during the vacation. So there is no interim order passed in the writ petition with regard to the proceedings.
What is the order that is questioned here?
Where the order that is questioned is the visitation rights.
Where is that order?
Annexure A, page 29. That's what I was making myself. I am the petitioner. If he can just have some patience and allow me to convince the court.
No.
Let him have his patience.
But
Every time, I do not understand this. It's my duty.
I do agree.
I am the
Let
petitioner.
me
wants to argue-
understand what the petition is.
Petition is what it is.
Please,
Where is the
please.
question of making these as if we are before a family court and we can't behave like family court lawyers
You
also.
make your submission.
Yeah.
I will hear you.
That is, let him have his patience, my
That's
lord. He
all.
must learn.
That's all.
Because, my lord, now kindly see, let me explain slowly. Because your lordship, like rightly said, your lordship has not read the file.
I don't read the.
Read the file. That's a good habit, in fact, my lord. In my opinion, that's a very good habit not to read the file.
Yes.
And come with an open mind to the court. Very few judges can do that. Anyway, my lord, annexure A is the impugned order.
Yes.
Petitioner before your lordship, my lord, is the husband. Respondent is the wife. Now, my lord, only the petitioner has filed a petition for divorce and under the Guardian and Wards Act to be appointed as a guardian. Wife has not filed. She had filed and she has withdrawn. So the question now for the family court is whether a divorce should be granted on my petition and whether I should be appointed as a guardian, because that is the only question. I may fail or I may succeed before the family court is another aspect of the matter. Your lordship, don't you have to trouble yourselves on that? During the pendency, as it is usual, my lord, I as a father, am entitled to visitation right. Nobody can deny my visitation right, my lord, especially, my lord, there are a number of Supreme Court citations also, which I will cite on that. What happened? I filed an IAM, my lord, for visitation right. It is allowed, but in what condition, your lordship may kindly see is annexure. Not that it is rejected. Now, kindly see the order, what impugned. I'll not read the whole order, my lord.
Yes.
Page 29 is the impugned order, annexure.
Yes, 37 operative portion.
Yes, 30, exactly, my lord. I was coming to that. No, it doesn't matter. 37, his lordship is right. 37, my lord, is the operative portion. 30 is the operative portion, my lord. Ink page 30, your lordships may get it.
30.
Yeah, 30. What? My lord, I have filed a separate memo with all orders. Your lordship don't have to trouble yourself. Kodi, madam. On separate memo with all orders. So your lordship did not have to keep on shunting between the papers, because there are about 9 orders passed by this court. This is the memo. This content, and I have a copy on the other side. All orders are in this, my lord. Your lordship don't have to trouble.
Yes, sir.
Take the trouble.
30.
Page 30. This is the impugned or part of the impugned order, my lord. It starts from page number 29 onwards.
Yes, sir. Yes.
Now let me take your lordship directly to page 30.
Yes.
Since January 2020, my lord, this is during COVID period.
Yes. Yes. Yes.
Till today, pandemic COVID-19 is going on. And another virus came by name of Omicron. About 2 years due to pandemic COVID-19, classes were also going on through online, and there is no freedom to the human being to move from outside the home. In such a situation, welfare of the children is also important. Presently, respondent taking care of her child at her house, whatever it is. Therefore, in such a situation, visitation right of the first half vacation and also for celebration of functions at Mumbai is dangerous to the world. This is what he says. Their father has got right to meet his child. So my right is not denied, and there is no counter petition or counter appeal or a counter objection. So this finding, my lord, that I have a right to meet the child has become final and conclusive. Meet the right. Therefore, it is just and proper to give a visitation right on alternative Sunday, 11 a.m. to 4 p.m. Alternative Sunday, 11 a.m. 4 p.m. visitation right. With some conditions in the interest of the child. Fair enough. Accordingly, petitioner is permitted to make a video call to the child in alternative days for 1 hour. Accordingly, I proceed to pass the following order. Sunday 11 a.m. to 4 p.m. till disposal of the main petition. Petitioner is permitted to make video call on alternative day about 1 hour. Respondent is directed to hand over the child to the petitioner on specific time mentioned above, and petitioner is directed to consider the likes and dislikes of the child. Further, petitioner is directed not to give ill advice about the respondent to the child while exercising. So this is the order which we are called in question on the ground, my lord. I, as a father, wanted 50% of the visitation right during the vacation. I have a right to meet my own child, and I wanted on every alternate meeting to come to Bangalore, because I am a resident of Bombay. The respondent, who is a doctor, practicing doctor, is a resident, my lord, of Bangalore. I have to come all the way from Bombay on every weekend and spend a night with my child. These are all the prayers which I made in the application. Now, we called in question this, my lord, because this COVID was there, is no doubt. But the curtailing my right to meet my child, take my child to Bombay, was called in question. Based on this, my lord, first order came to be passed by this honorable court, my lord, your lordship will kindly see, was passed after interviewing the child by this honorable court on 24/20/22. That page number 38. The first order. There are 9 orders passed by this court.
So that is after this order.
Yes, after this, in this writ petition which your lordship is hearing.
All right.
Now, what I am submitting is, my lord, that COVID situation is all past, gone history.
Yes.
That will not survive, my lord. The application of mine, now what this honorable court has done, by consent of both the parties, can be made.
Where is that order?
The first order will be page 38.
Yes, 38.
The starting of the order is at page 37, my lord.
Yes, yes, yes. No
His
problem.
Lordship Justice Pandit.
Yes, yes.
24/2022 was the first order, my lord.
Yes.
My lord, there in the middle, kindly permit me to read, learned counsel for the respondent wife and then Bharat. In the middle. First para in the middle, at page 38.
Respondent wife. Ah.
Counsel for respondent wife referring to the statement of objection submits the child needs guidance and help of the mother. As such, custody of the child should not be given. This is their contention.
Yes,
But
overrides.
before this also there are certain orders, my lord, of the magistrate court in DB case, where the courts have come heavily upon the respondent and made observation that also we have produced, that she is trying to prevent him from meeting. She is not conducting herself in a proper manner. She must conduct, because she is trying to act as if, my lord, she alone has the right, snatching that child, not allowing him to. All those observations are there. But this is the Honorable High Court first order in this writ petition.
Yes, yes.
So they objected to give custody, child may not be given for overnight. It is submitted that child is comfortable to spend time with the father under supervision of the mother. This was their contention, my lord. My lord, the child was called, his lordship just interviewed the child, my lord, and then in the matter of child custody, first and paramount consideration is welfare in the interest of the child and not the rights of the parents. Custody, interim or final, has to be decided on its own facts. The child cannot be treated as a property or a commodity. The issue of custody of minor child is to be dealt with. This court, by order dated 12/4/2022, direct respondent wife to make available the child for interaction in the chamber. So, my lord, the child was interviewed by his lordship, my lord. He was interviewed on by order dated 12. Accordingly,
Yes.
accordingly, I had interaction with the child. During interaction, it is revealed that child is studying in first standard and after summer vacation would be attending second standard. Further, during the course of interaction, it was found that child likes his father. So there is no allegation against me or counter allegation about my relationship with my son, and this honorable court found that he likes me, my child likes me. Father, and he wants love and affection from his father. But at the same time, he stated that he would not be comfortable with the father without the company of his mother. Be that as it may be, father has the right to have custody of the child, and he has also got a right to enjoy the love and affection of the child. The child likes to have company of the father and has equal right to enjoy the love and affection. But at the same time, sentiments of the child is to be given due respect. In the circumstances, I deem it appropriate to grant visitation right to the father every Saturday and Sunday during summer vacation or the 1st of June 2022. This is the first month. On every Saturday and Sunday, I had the visitation right. Then, father is permitted to have visitation right between 9 AM to 6 PM on every Saturday and on every Sunday between 11 AM and 5 PM. The respondent is directed to hand over custody of the child to the petitioner father. At the same time, at the time stated above, Saturday, the petitioner father shall hand over the custody of the child in the evening at the time. Petitioner shall pick up the child from the place of the respondent and drop back the child to the petitioner father. Shall not take the child outside the jurisdiction of Bangalore Metro. Malad, this was the first order, Malad. Malad, let me make a submission, Malad. We complied with it, and there is no grievance, Malad, that I obeyed the order. Not that I took the child or I didn't hand over or there was any trouble or anything like that. This is regarding number one, visitation right when I come to Bangalore. And this has been followed and there was no harm caused. This can continue till the disposal of the petition. How is it? Now, next comes regarding vacation, school vacation, whether a second order was passed by his lordship Justice Dixit, my lord, on